We were discussing criminalization. I mean, you are well aware of the fact that we already have people with criminal backgrounds, people, facing criminal charges who already occupy parliament as well as the assemblies. What is that one reform you think that will take care of this menace?
Yes, you are very right. This is something which is very embarrassing. I would like to tell you, while the whole nation is thinking that we are a rotten country and everybody is steeped in corruption, there are good things also happening to the nation. Our election system is regarded worldwide as
Example.
as an example. In fact, if I may refer to Hillary Clinton's comment that it is a gold standard in election. The fact the whole world admires our election system, they admire our democracy. At the same time, when they ask us questions about the number of people with criminal background in the legislature, it does make us lower our eyes. And I think the reforms which are being proposed, and if candidates, at least with heinous offences like dacoity, rape, murder, kidnapping, to start with, we had called a meeting of all political parties about a couple of years ago, and all of them expressed reservation about this proposal, with a reason which also has some merit in it. They say that in politics sometimes false cases are filed against each other. In such a situation, it will be unfair to disqualify somebody. Now, for our answer is that okay, we will not take like picketing or libel or small cases. At least the serious and heinous offences which will lead to imprisonment of 5 years or more, and safeguard is that police FIR you may not trust, but the charges would have been framed by a court of law. The court of law is independent. There is a judicial application of mine, even if it is prima facie at that stage. Thirdly, such cases should have been filed at least 6 months before the election. With these safeguards, and if we make a beginning, otherwise, second alternative also which should be considered at the same time, already on conviction, even on day's conviction for corruption, for untouchability, there are many offences. Even one day's conviction leads to your disqualification. The other alternative is that we should expedite, we should the trial of such cases so that conviction can take place not in 20 years, not in 30 years, but in a year or two. And I think that will be the best. So two things together should be looked at.
You're saying if charges are framed, you should be disqualified from contesting an election. However, the politician will argue that we are innocent until proven guilty, and I'm sure they're resisting this particular reform.
Yes. No,
what is the response
yes.
of the law minister who you said has visited your room twice?
Yeah. Now, you're right, that's what many people say, not just the politician, but even some jurists say, that law of the land is you are innocent till proved guilty. But my answer to that will be a counter question. Look, in Indian jails today, we have about 4 lakh prisoners at the moment, of which 2,68,000 are under trial. Now, they are innocent. And while they are innocent, you are taking away 4 of their fundamental rights: right to liberty, right to freedom of movement, right to their occupation, whatever they want to do, and the fourth, which we recently saw in a Supreme Court judgment, right to dignity. Now, if you can take away 4 fundamental rights of an innocent person who is really under trial, now right to contest is not even a fundamental right. So that's what we would like the government to consider.
But how much resistance are you facing from the government, the political class, on just this one reform?
Well, the feedback that we got was that this concern was expressed in all 7 and by the chief ministers of different political parties. Because obviously this is a serious concern for them. While they're concerned about the problem, but a reasonable way has to be found. Probably, maybe we can accelerate the alternative route of expeditious disposal of cases. Then there is nobody can question, because once convicted, then even if you're in appeal, then you are still disqualified. But there is one more problem. If a minister is convicted during his term, then he continues to occupy that office. I think, or an MP or a minister, then he is not disqualified. He is disqualified only from a future date. But I think this also can be now considered in the package.